Hey, welcome back. This is Study for the Bar in Your Car. I'm your hostess with the mostest, Angela, and I am a law student studying for the bar exam just like you. Anyhow, you know how this works. So I do the introductions, and then I do the outgoings, but the middle part, those are my AI buddies. I don't have names for them. Shall we name them? I don't know what to name them. Maud and Claude, maybe? Now, Maud and Claude, what they do is they do a deep dive through my notes. So all throughout law school and all throughout bar study, I've been taking copious notes. I've got so many bar notes, my own outlines. I put that into AI. I had AI spit out a podcast. So it's sort of a podcast within a podcast. So this is me, Angela, your real life hostess, but soon you'll be listening to our AI host who do a really good job of going through the information. But what you don't know is that I spend a lot of time organizing the information even before they get to it. So there's some oversight here. Okay, a few things. I'm not an attorney. I'm a law student just like you. I'm not giving legal advice. Sometimes AI isn't 100% correct, so take all of that with a grain of salt. But I have done my best to go through and make sure that what is up there is comprehensive and is right as far as someone who is not barred by the state, knows. I am barred with 2 Native American tribes though. So that's a whole separate thing that I will talk about in one of the further podcasts that I do. A couple other things. I want you to please subscribe to the podcast. I know we're only episode 2 in. There are 9 episodes here in civil procedure. So we have an introduction, we have a wrap up, and then in between we've got 7 more episodes. So we go through things really thoroughly. So please subscribe, and I will try to update this every few days, until we get to the bar. So I am taking the bar. I don't want to say where I'm taking it yet. I'm going to have you guys guess, but I'm not taking it in the area where I live. I have to do some travel. And wouldn't it be great to be able to listen to a podcast while I'm traveling on the airplane? All right. I am not asking for donations. I am a poor law clerk, but what I am asking is if you are an attorney or if you know an attorney who needs help, if they have too much work and they need someone else to just get in and help them out, recommend me. You can find me at hello@legalwriterandlawclerk.com. I know these email addresses are so long. My URLs are so long, but you get the idea. Angela@legalwriterandlawclerk.com or hello@legalwriterandlawclerk.com. And then if you want to contact me about this podcast, it's another long one. It is podcast@studyforthebarinyourcar.com. Okay. A few other things. I'm not an attorney. AI is not always right. Be safe when you're driving. Don't get too distracted. And that's about it. So for this podcast, here's the topics we're going over. We're going over federal subject matter jurisdiction, federal question jurisdiction, diversity, supplemental jurisdiction, and removal. So basically removing things from, removing cases from one court to another. We also go over remand, personal jurisdiction, service of process and notice, venue, forum, nonconvenience, and transfer. Did you ever notice that when you study forum nonconvenience, every time I see a question on it when I study for the bar, it involves like an airplane or a crash or something like, I don't know, it always sounds so tragic and some other country has to deal with it. Anyhow, so enough of me blabbering on. Let's get to our AI host, Maud and Claude, I guess, whatever their names are. If you have a better name, make a suggestion to me. All right, here we go, and thanks for tuning in. I'll catch up with you shortly.
Welcome back to the deep dive. Today we're doing something a bit special. Think of it as study for the bar in your car, but, deep dive style.
Exactly. And a big thank you to Angela, an LLM student who put together these great notes we'll be working from.
Yes, Angela's notes are our guide today. We're focusing sharply on what you need for the bar exam. Federal subject matter jurisdiction, personal jurisdiction, service.
Venue, forum nonconvenience, transfer, all those key federal procedure topics.
Right. Our goal is to break these down, make them clear, hopefully a bit less intimidating for your bar prep.
Definitely. We want this to be helpful, encouraging. We'll use Angela's notes and some real-world examples to make sense of it all.
Okay, let's jump in. Subject matter jurisdiction, the big one. Federal courts are courts of limited jurisdiction, right? Not like state courts.
That's the absolute starting point. They can only hear certain kinds of cases. You always have to ask, does this federal court even have the power to hear this case?
And what are the main ways they get that power? The main categories we need to know cold for the bar.
Well, there are 4 main gateways: federal question, diversity, supplemental jurisdiction, and removal. If your case doesn't fit one of these, you're probably in the wrong court system.
Okay, let's start with federal question. How does a case get into federal court based on a federal question? What's the core idea?
The core idea, coming from cases like American Well Works, is the creation test. Basically, does the plaintiff's claim itself arise under federal law?
Meaning like a federal statute gives them the right to sue.
Exactly. A classic example Angela notes is the Federal Tort Claims Act, the FTCA. That law lets you sue the federal government for certain torts. So if you sue under the FTCA, boom, that's federal question jurisdiction. The right itself comes from federal law.
Got it. But what if it's a state law claim, but there's sort of a federal issue mixed in? Does that count?
Good question. That's where the well-pleaded complaint rule comes in. You look only at the plaintiff's complaint. The federal issue has to be essential to the plaintiff's claim, not something brought up in the defendant's answer or defense.
Okay, so it has to be on the face of the complaint.
Right. But there's a bit more nuance, sometimes called the gravel test. For those trickier cases where a state claim seems to depend on interpreting federal law, the court asks, is the federal issue necessarily raised? Is it actually disputed? Is it substantial? And can we decide it in federal court without messing up the balance between federal and state courts?
So it can't just be sort of related. It has to be like a really core part of the plaintiff's case.
Precisely. The bar examiners love testing that edge.
Okay, federal question based on the plaintiff's claim arising under federal law. Let's move to diversity jurisdiction. What are the must-knows here?
2 absolute pillars for diversity. First, complete diversity of citizenship. Second, the amount in controversy must exceed $75,000. Not equal, exceed.
Exceed $75,000 and complete diversity. What exactly does that mean? No overlap at all.
Exactly. No plaintiff can be a citizen of the same state as any defendant. Every single plaintiff has to be diverse from every single defendant.
Okay, and how do we figure out citizenship for the bar? For people, for companies?
For individuals, it's their domicile. That's their residence. Plus, the intent to remain indefinitely, not just where they happen to be living.
Intent is key.
Crucial. For corporations, it's 2 places: the state where they're incorporated and the state where they have their principal place of business.
The nerve center test from Hertz.
That's the one. Where are the top executives actually directing, controlling, and coordinating the company? Usually, yeah, it's the headquarters. You need to nail down both for corporations.
And what about things like LLCs or partnerships? They pop up on exams, too.
Right. For unincorporated entities like LLCs, partnerships, unions,
Yeah.
you look at the citizenship of all their members or partners. An LLC is considered a citizen of every state where one of its members is a citizen.
Wow. Okay, so one member in the same state as a defendant can destroy diversity for the whole LLC?
Correct. It makes achieving diversity harder with those entities.
Yeah.
Also, remember permanent resident aliens, they're treated as citizens of the state where they are domiciled for diversity purposes.
Good point. Any exceptions?
Well, there's a statutory bit, 1332A3, that allows jurisdiction when you have citizens of different states and foreigners are additional parties. The presence of the aliens doesn't automatically kill diversity if the U.S. citizens are diverse.
Okay, so diversity. Complete diversity between all plaintiffs and all defendants and over 75K longs. Got it. What's next? Supplemental jurisdiction.
Yep, supplemental jurisdiction. 28 U.S.C. Section 1367. This is how a federal court with jurisdiction over one claim, say a federal question claim, can sometimes hear related state law claims in the same lawsuit.
Even if those state claims wouldn't qualify for federal court on their own.
Exactly. The idea is efficiency here, the whole dispute at once. But the claims have to be related.
How related?
They need to arise from a common nucleus of operative fact. meaning they stem from the same basic event or transaction, same story, essentially.
Makes sense. But are there catches, especially in diversity cases?
Big catches in diversity cases, covered in Section 1367B. This is super important for the bar. Generally, in a case based only on diversity, the plaintiff cannot use supplemental jurisdiction to bring in claims against parties added under certain rules like Rule 14 impleader, Rule 19 joinder, Rule 20 joinder, or Rule 24 intervention.
Whoa. Okay, that's a mouthful of rule numbers. What's the simple takeaway?
Think of it this way. Plaintiffs can't use supplemental jurisdiction as an end run around the complete diversity or amount in controversy rules. If adding that extra claim or party would break diversity, 1367B usually says no.
So, if I'm a California plaintiff suing an Arizona defendant for $100,
Standard diversity.
and my friend, also from California, wants to join and sue the same Arizona defendant for $50 based on the same accident.
That likely won't fly under supplemental jurisdiction. Even if it's the same accident, letting the second California plaintiff join would violate complete diversity. They'd need their own basis for federal jurisdiction, like meeting the amount in controversy themselves, which they don't hear.
Okay, that clarifies the 1367B limitation in diversity. Are there other reasons a court might refuse supplemental jurisdiction?
Yes, under 1367C, the court has discretion to decline. Maybe the state law issue is really novel or complex, or the state claims start to overwhelm the original federal claim, or maybe the original federal claim gets dismissed early on, or, other exceptional circumstances.
So it's not automatic even if the common nucleus test is met.
Correct. There's a layer of discretion involved.
All right. Let's talk about getting a case into federal court when it didn't start there. Removal.
Right, removal. 28 U.S.C. Section 1441. This lets a defendant move a case from state court to federal court, but only if the case could have been brought in federal court originally.
So it needs either federal question or diversity jurisdiction.
Exactly. If the federal court would have had original SMJ, the defendant can generally remove it.
And where do they remove it to? Which federal court?
To the federal district court, whose territory geographically includes the state court where the case was filed. Venue under 1391 isn't the issue for removal. It's about matching the federal district to the state court location.
Okay. Who gets to decide to remove? Just one defendant?
Generally, all defendants who have been properly served must join in or consent to the removal. It's usually a collective decision. And crucially, only defendants can remove. Plaintiffs can't remove a case they filed in state court.
Makes sense. Any big limitations on removal, especially for diversity cases?
Yes, a huge one, often tested, the in-state defendant rule. If jurisdiction is based only on diversity, the case cannot be removed if any defendant is a citizen of the state where the suit was filed.
So if a Texan sues a Californian in California state court, the Californian defendant cannot remove based on diversity.
Correct. Even if there's complete diversity and over 75 KAT, the in-state defendant blocks removal.
What about timing? How long do defendants have?
They have 30 days after receiving the initial pleading or summons, whichever shorter, or I should say whichever comes first that gives them notice.
Just 30 days.
Yes. And if the case isn't removable initially but becomes removable later, say a non-diverse defendant has dropped a new 30-day window, starts from when they learn it's become removable. But there's an absolute one-year limit on removing diversity cases, measured from when the case was first filed in state court.
Okay, tight deadlines and that tricky in-state defendant rule for diversity. That covers subject matter jurisdiction. Let's shift to personal jurisdiction, power over the parties themselves.
Right. This is about fairness to the defendant. Does this specific court have the power to require this specific defendant to show up and defend the case? It's all grounded in due process.
The key phrase is minimum contacts, right?
Absolutely. The defendant needs sufficient minimum contacts with the forum state, the state where the court sits, so that suing them there doesn't offend traditional notions of fair play and substantial justice. International Shoe is the landmark case.
What kinds of personal jurisdiction do we need to track?
Primarily, you need to know in personam jurisdiction over the defendant's person. Then there's in rem jurisdiction over property within the state. And quasi in rem also based on property, but for a personal claim. In personam is the most common and heavily tested.
Okay, focusing on in personam, how do we establish those minimum contacts? What are the main ways?
Two main types: general jurisdiction and specific jurisdiction.
General first.
General jurisdiction means the defendant's connections to the forum state are so continuous and systematic that they're essentially at home there.
At home, like we talked about for diversity. state of incorporation and principal place of business for a corporation.
Exactly. If a court has general jurisdiction, the defendant can be sued in that state for anything, even if the lawsuit has zero connection to that state. But the Supreme Court says this is rare, the bar is high, just doing a lot of business isn't usually enough to be at home.
Okay, so general jurisdiction is tough to get. What about specific jurisdiction?
Specific jurisdiction is case-specific. It means the lawsuit arises out of or relates to the defendant's contacts with the forum state.
So the defendant had to do something in that state related to the lawsuit.
Pretty much. We look for purposeful availment. Did the defendant intentionally direct activities toward the foreign state? Did they reach out? Take advantage of the state's laws or market?
Okay, purposeful availment. What else?
Relatedness the claim has to connect to those contacts. And foreseeability isn't enough on its own. The defendant must have reasonably anticipated being hauled into court there because of their actions there. Think worldwide Volkswagen.
And it also has to be fair, right? The fair play and substantial justice part.
Yes, the court balances factors. The burden on the defendant, the state's interest in the case, the plaintiff's interest in getting relief there, the efficiency of the court system, shared state interests. Asahi laid out these fairness factors.
Can you give an example like the insurance one from Angela's notes?
Sure. The McGee example is great. A California resident buys life insurance from an Arizona company with no offices or agents in California. The company mails the policy to California, collects premiums from California. When the insured dies, the beneficiary sues the company in California.
Does California have specific jurisdiction?
Likely, yes. The company purposefully reached into California to sell and service the policy. The lawsuit arises directly from that single policy, that contact. It's foreseeable and likely fair to make them defend there. Even one contact can be enough if it's the very thing the suit is about.
That really helps. What about the other types? In rem and quasi in rem. Quick refresher.
In rem is jurisdiction over property itself, like a dispute about who owns a piece of land located in the state. The property is the focus. Quasi in rem uses property in the state as a basis to bring a defendant into court on an unrelated personal claim, but the judgment is limited to the value of that property.
But didn't the later case limit quasi in rem?
Yes. Schaffer v. Heitner essentially said that even for quasi in rem, you usually still need the defendant to have minimum contacts with the state, connecting back to the international shoe standard. So just owning property there isn't automatically enough anymore.
Okay, jurisdiction covered. Now, how do we actually start the lawsuit? Service of process. Getting notice to the defendant.
Rule 4 of the Federal Rules of Civil Procedure. That's your guide. It's about constitutionally adequate notice, making sure the defendant knows they're being sued and has a chance to respond.
What are the main ways Rule 4 says you can serve an individual?
Several options you need to know for the bar. You can follow the state law rules for service in the state where the federal court sits or where service happens. You can do personal delivery, hand it right to them.
Okay.
You can leave it at their dwelling or usual place of abode with someone of suitable age and discretion who lives there.
Not just any person at the house.
Right, someone suitable who resides there. Or you can deliver it to an agent authorized by appointment or by law to receive service.
And for corporations.
Often delivering it to an officer, a managing agent, or a general agent. Angela's notes mention delivering it to a CEO at headquarters usually works. Again, state law options are often available too.
What about this waiver of service thing?
Rule 4D. The plaintiff can mail the defendant the complaint and a waiver form. If the defendant signs and returns the waiver within 30 days, 6 if outside the U.S., they waive formal service.
Why would they do that?
They get longer to answer the complaint 60 days instead of 21, or 90 instead of 21 if outside the U.S. It saves them the potential cost and hassle of formal service. If they refuse to waive without good cause, they might have to pay the costs the plaintiff incurs in serving them formally.
Is there a time limit to get service done after filing the complaint?
Yes. Rule 4 meter. You generally have 90 days after filing the complaint to serve the defendant. If you don't, the court must dismiss the case without prejudice unless you show good cause for the delay.
And good cause is hard to show.
Usually, yeah. Simple mistakes or neglect typically don't count. You need a legitimate reason. And remember, after service, you file proof and affidavit of service with the court. Improper service means any judgment is void, even if the defendant knew about the lawsuit.
Okay, proper service is non-negotiable. Now, assuming we have SMJ, PJ, and proper service, where within the federal system should the case be heard? That's venue, right?
Exactly. Venue is about the proper district. 28 U.S.C. Section 1391 gives the main rules.
What are those rules? Where is venue proper?
3 main possibilities. 1,
Yep.
any district where any defendant resides if all defendants reside in the same state.
Okay.
2, any district where a substantial part of the events giving rise to the claim occurred, or where a substantial part of the property involved is located. This is often the key basis.
Substantial part. Got it.
3, if neither 1 nor 2 works, which is rare, then venue is proper in any district where any defendant is subject to personal jurisdiction for that specific action.
Yeah.
This is a fallback.
Okay, so usually where defendants live or where the key events happened, what if venue is proper, but it's just really inconvenient?
That's where transfer and forum nonconvenience come in.
How are they different?
Transfer, under Section 1404A, is moving a case from one federal district court to another federal district court where it could have been brought originally. This is done for the convenience of parties and witnesses in the interest of justice.
So staying within the federal system.
Right. Forum nonconvenience, FNC, is different. That's when the court dismisses the case because there's a much more convenient court available in a different judicial system, usually a foreign country.
So the federal court just says, nope, goes sue somewhere else.
Essentially, yes.
Yeah.
But it's a high bar. Courts consider public and private interest factors, access to proof, witness convenience, local interest. FNC is rarely granted if the plaintiff is a resident of the forum. And if it is granted, the defendant usually has to agree to jurisdiction in the other forum and waive defenses like the statute of limitations.
Okay, transfer within federal courts, FNC dismissal to go elsewhere. What about contracts where parties already agreed where to sue? Forum selection clauses.
Federal courts generally enforce valid forum selection clauses quite strongly, thanks to cases like Atlantic Marine. If the clause points to a specific federal district, a motion to transfer under 1404A is the usual way to enforce it. The clause basically overrides the normal venue analysis for convenience.
Even if state law might not enforce that clause?
Yes. Federal law governs enforcement of these clauses in federal court transfer motions.
Wow, okay. That's a lot, but incredibly helpful. Subject matter jurisdiction, personal jurisdiction, service, venue, transfer, FNC. It really covers the framework for getting a case properly into and situated within the federal court system.
Absolutely. These are the building blocks you need. And like we said, dive back into Angela's notes for more details. And those examples, they really help solidify the concepts.
Definitely. Okay, final provocative thought for everyone listening and studying. We just talked about federal courts enforcing forum selection clauses, sometimes even when state courts wouldn't. Think about what that means when you're advising clients or even drafting contracts. Where you might end up litigating can be heavily influenced by that clause, especially if you anticipate ending up in federal court.
A really practical point to consider. It highlights how these procedural rules have real-world consequences.
Exactly. All right, that wraps up our deep dive on these federal procedure essentials. Keep studying hard, stay focused, you've got this.
Best of luck with your bar prep. We'll catch you next time.
Hey everyone, I'm back. It's Angela, your living, breathing, not AI hostess. So I hope you enjoyed that rundown of federal question jurisdiction, subject matter jurisdiction, diversity, supplemental jurisdiction, removal, personal jurisdiction, service of process, notice, venue, forum nonconvenience, and whatever else they want to call it. If you need to contact me, you can contact me at studyforthebar.com. And if you'd like to contact me regarding any potential legal work, if you're an attorney or if you know an attorney who needs help, essentially, I'm a ghostwriter for attorneys. So you can reach me at hello@legalwriterandlawclerk.com. In any case, thank you for tuning in. Please subscribe, and we have more episodes on civil procedure coming up.